All right, everybody. So on behalf of Apex Training, Performance Title and Escrow, Trident Title, welcome all. Thank you guys for being here on our very first edition of what we are calling Better Call Paul. If you did not get the reference, it's a spinoff of a hit TV show, Better Call Saul. And our goal is that every Thursday we're going to provide this to you guys so that you can get questions answered about what's going on in our marketplace right now, local issues, and be able to cover what's going on in the market, especially as things are rapidly changing. So questions today that we're going to make sure we hold to are going to be about title insurance and about settlement services. So on behalf of all of us, I do want to welcome Paul Krasker. He's going to give a little intro as well. Thank you, Paul. Take it away.
Great. So I did a talk, I think it was probably 2 weeks ago, and I gave some initial comments on what was going on in the county specifically and the state about what's happening with whether this is a force majeure or not. And as I said earlier, there is no appellate case law that determines what is and what isn't a force majeure. Last Sunday, the Palm Beach Post did an article and quoted from Gary Nagel, who's a good real estate lawyer in town. I had a couple quotes in there, and they had to go all the way to Broward County to find somebody to argue the other side of it. They acknowledge that there is no definitive answer today as to whether this is a force majeure. The arguments for it being a force majeure are that there are people under travel restrictions inside and outside of the state, and there are requirements in the contract that provide a buyer the right to do a pre-closing walkthrough. And at this time, many people are unable to accomplish that task. Now, the arguments that the sellers are making on the other side is you can certainly have your realtor do the pre-closing walkthrough for you, and that there's no requirement, if it's a cash deal, for the buyer to actually do it themselves, that the contract says at buyer's election, the buyer can appoint a representative. I still don't think that there's any clear answer to these issues, and I'm currently in about 3 or 4 escrow disputes over those same issues. So there is no clarity there. I doubt that the governor's office or the county commission are going to jump into this legal issue. So until then, you're all going to have to work it out and figure out creative ways to either keep deals together or negotiate settlements of escrow amounts and walk away. Not sure that there's much else. I should state that on March 2nd, the governor issued a 45-day executive order that stopped people from getting final evictions, basically writs of possession, and stopped people from doing foreclosure sales. His executive order did not stop the lawsuits from being filed or the lawsuits from progressing forward. They just stopped the end result from happening. And that order is set to expire tomorrow. I've been told that there's an update from the governor's office coming out at either 5 p.m. or 6 p.m. And we expect that there'll be a continuation of that order and potentially an amendment of that order. But most crucially, with regard to mortgages, with regard to rents, the executive order did not say that you don't have to pay, and did not say that the tenant or the borrower are absolved from any monies that they're not able to pay. I guess that's a good starting point to stop and start taking some questions.
Yeah, absolutely. So let me feed you some of the ones that I got, and then I think that's going to answer a lot of other people's questions, and then we'll kind of go from there. So 2 of the big questions that we were getting is there an update or thoughts on force majeure, which you covered, and is coronavirus considered an act of God, which you covered. So This is an interesting one. This is from Mike in Wellington. So can an agent offer a 10% post-closing rebate or refund from the agent's commission to any buyer or seller who is a first responder or in the healthcare industry? The agent is aware that he may issue a credit at closing to offset closing costs, but think it'll be more impactful if he can simply issue a check to the customer from his own operating account shortly after closing. Is something like this possible without violating rules or laws? If not, is there any other way that you can think of that this would be done?
So the short answer is that the state actually encourages people to rebate money to their clients. It's the legality about rebates is always when people are trying to give it to a third party. You know, a title company out there that's offering you a free transaction coordinator in exchange for you sending them their title work is an unauthorized gift. But if you're giving money to a borrower or a buyer or a seller, that's absolutely allowed and encouraged. The exception is if it's not disclosed and it's part of a loan. So if there's a loan that's being given to the buyer, you all probably understand that that lender wants to make sure the buyer has some skin in the game and puts enough money down that they're not just going to walk away in default the first time that there's some hardship. So if you don't disclose that you're giving them a check for $10,000 a day after closing, then you could be stuck with having violated a mortgage law.
Great.
Hey, Paul,
And Jason just said something that's really important with that. The state will always be okay if the consumer is getting the benefit. What we're trying to get away from is the consumer being misled or not receiving the benefit. If the consumer is the one that's receiving the benefit, we're going to be okay. So Mike's on here, and that was his question. So Mike, if you have a follow-up, jump on.
yeah, thanks for that answer, Paul. So where would you disclose it? So if it's not being paid at the closing, it wouldn't go on the CD. Would it be in the contract?
So if it's a mortgage transaction, it should be disclosed to all parties, including the bank. So you'd want it on the CD. And then it can go right on the closing statement. That's the best place for it. Everybody signs off that they knew about it. The lender has previously approved the CD, so there's no question that they knew. And you could do it as a whatever it is, a 5% credit of your brokerage commission to the buyer, to the seller, and have it right on the first page that says first responder, healthcare, thank you, broker credit, something like that.
The question that was presented to me, Paul, was whether or not they could do it post-closing. So I understand what you're saying. You put it on the CD and you offset closing costs. You give a credit at closing from your commission. But in this case, the agent was wondering whether or not they can get the full commission at the closing, and then post-closing, run it through their own personal operating account, and then post-closing, issue a check back to the customer, whether it be a seller or a buyer.
So if there's no pre-agreed contractual obligation, so if a nurse didn't go to that agent because of this deal, and they're relying on this kickback, rebate, whatever you want to call it, after closing as part of the reason why they use that agent, if this is just a great thing that they're doing in the marketplace, then, and there's no expectation that they get this money, then you could do it at any time. Again, if there's a contractual agreement that this person's coming to you up front because you've said you're going to kick 10% of your commission back to them as a healthcare first responder, then that needs to be disclosed to the bank in writing prior to closing. And then once that's disclosed to the bank, it can or can't be on the HUD. I'm sure the bank's going to want it on the HUD if they allow it. But yeah, that's what you'd want to do, is disclose it to the lender prior to closing, and then you could do it.
Okay, thank you, Paul.
Awesome, thanks. All right, on to Sarah from West Palm. A buyer didn't close on his scheduled closing date, claiming 18G on the as-is contract. It was a cash transaction, and the inspection period right to cancel had already expired. The buyer lives locally in Florida, so inability to travel to Florida is not the issue. Buyer and seller are each making a claim on the deposit being held. Can the property be put back on the market into the MLS as active while the issue is being figured out by each party's attorney? And could potential litigation prevent the property from being sold again? Is there anything the listing agent has to disclose, either in the MLS or the broker's remarks or anywhere towards a future buyer or contract about this, so that the incoming buyer knows, there's a holdup?
So a few things in there. First being, I don't think it matters too much whether they're local or from New York or from Boston, where there's a stay-in-place order. The risk is that somebody gets infected while doing a pre-closing walkthrough, whether it's because the movers were through there the day before and one of the movers has COVID, whatever the factors are. And it's more about the buyer. It's more about what risk factors there are. I've had a buyer who had asthma who is in their 70s, and they're just not going outside, period. I don't care if it's next door. And that issue will be decided was, can you take that position, or do you have to give somebody else who's willing to go in there the right to act on your behalf? So that's that one piece of this issue. The other piece about whether you can remarket that property, yes, you can, period. What you want to do before you remarket is you want to make sure you get in writing from the other side that this is an issue about the escrow, that they're not seeking specific performance, that they are seeking to cancel the deal under COVID. And once everybody agrees with that, say, listen, okay, we're going to park this escrow money on the side. We're going to go to mediation, and then we're going to go to litigation, period. Once that happens and you've parked that escrow issue as an escrow issue, you can go forward. You can go forward and remarket and resell that property, period. The risk for you is that the buyer makes a claim for specific performance. So a lot of these sellers are taking a very firm position. A lot of the buyers are saying, I want 30 days. I want up to 30 days to see if this passes before I have to take action. And I'm using paragraph 18G to request it. And a lot of the sellers, their initial response isn't, well, I reserve my right to argue that this was not a force majeure, but I'll grant you the 30 days and we'll extend the closing to such and such as long as you'll agree to pay the carrying costs, whatever the negotiation is. The people who don't take that step, and the people who say, no, if you don't close on Tuesday, you're in default and I'm keeping your deposit money. If I'm a good buyer's attorney, the first thing I do is I say, I'm seeking specific performance under the contract. I want the seller to live up to their obligations under the contract. You had to give me 30 days, and once that 30-day time period was up, then you have the ability to go after my deposit or to close, either one, but you can't market it to anybody else during this 30-day time period. So again, if you can hold this off as an escrow issue and get a buyer who says, listen, I'm out, I'm canceling this deal, it's all about whether I have the right to cancel or not, then you can remarket. If, on the other hand, the buyer turns around and writes an email that says, that I've written a few times in the last month, that says, I don't believe the seller has properly conducted itself, and in fact, I think there's a specific, if I have to, I'm gonna sue for specific performance to make the seller grant us that 30-day window so that we have the right to buy it if everything passes and the world is what we think it's gonna be.
So, Paul, so, hi. So the buyer has to request that of the seller to the extension, or is it automatically, how does that, because in this instance, the buyer, to my knowledge, has not requested anything of the seller to extend based on the force majeure.
They just didn't show up?
Just didn't show up.
Okay. Yeah, I would send them a letter, email, whatever it is, saying, you know, you missed your date. We're surprised and trying to determine what your position is on these matters. You know, obviously it'd help to mitigate the issues between the parties if you would authorize us to begin remarketing this property and look for a third-party purchaser. There would be less money to fight over if we're able to sell this at a reasonable price to a third party. And if you lead them down that path, perhaps they come back and say, yeah, put it back on the market. Now you have their consent. They haven't made a claim for specific performance, and you're on your way.
So we have to, so we need to get something from the buyer saying that we're just agreeing this is going to be an escrow dispute and we're not going to.
Yeah, and I would send that email out, and if you don't hear from them in 2 days and they continue to stay silent, then I would send a follow-up email that says, and I still haven't heard from you. You didn't show up at closing. You didn't respond to my first email. I'm sending you this last email to let you know that we're going to remarket the property unless we hear from you to the contrary by tomorrow at 5 p.m.
Okay.
And that way their silence is allowing you to do it. You know,
Right.
they just can't sit there and watch you mow their lawn for 30 days and not pay you after the 30 days is up, kind of thing.
Right. So, and then, so there's nothing in MLS that we have to disclose as far as like any escrow, anything? No? Okay.
All right, great. Thanks, Sarah. All right, this one is from Chris and Sue Cull in West Palm. It's their listing. The buyer's mortgage period ended and they did not provide anything during that period. Now, a couple days after that period has ended, the loan officer sends a backdated commitment in an email that says that the buyer lost their job and cannot get the loan. What happens?
Yeah, so this is the one that everybody's fighting over now. That's my position from a buyer's perspective is that this COVID is preventing everybody from performing. But this is what's going to get litigated in the next year and a half. And 2 years from now, 6 months after the trial, there will be an appellate ruling that will be impactful to the extent that hopefully somebody had lost their job with the pre-approved financing, because that's 90% of these cases of people having to walk away. And, you know, there'll be a district court of appeal and ruling, and then somebody's either going to bring it to the Florida Supreme Court or let that sit. And once we have that, we'll know what the answer is.
I had a question about that, you know, because actually Chris had to go take a call with the seller that this is affecting right now to go break the news to him.
Yeah.
But, you know, in normal circumstances, and we've never had this happen. I know other people have. We've never had a closing that happened for. But if you get all the way to closing and, you know, they do an employment verification anyway, right? The day before closing or the day of closing, in some cases, they'll do another employment verification. You get to the closing table and the buyer has lost their job.
Sure.
So what happens in that case? Is that considered to be a condition of that loan commitment, or is that default?
Yeah, that's a default if there's no other factor involved. That's just a default. Buyer's responsible for maintaining their employment prior to closing. That's it.
Okay, so so in this case, you know, this case that we have, it's not really a COVID thing so much in this particular case, because this buyer failed to either supply a mortgage commitment or ask for an extension or kill the deal and let the commitment date lapse. So none of anything to do with the mortgage commitment now holds up anyway because it lapsed, right?
Well, no, that's not necessarily the case. What the argument they're going to make is I let it lapse intentionally because I had my mortgage. There was a condition that I be employed at the closing, as there's a condition on every loan, and I would have been employed but for this act of God, but for this event that nobody foresaw. And these are the types of events that people don't think maybe I should write into paragraph 20 that if there's a pandemic and I lose my job, I should get my deposit back. So,
hi, Paul. My understanding is that when the mortgage commitment is given during that 30 days, in that mortgage commitment, it states that it's contingent on verification of employment, day or two before closing, and that's the buyer's safety net. So if they do not give us that commitment in that 30 days, then 31 days, contract proceeds as normal, right?
Yes, as normal, but still subject to the paragraph 18G, still subject to the other two terms under the mortgage provision. So, for example, 2 days before closing, if you guys weren't pushing the buyer to get their appraisal done early, and the appraisal comes in $30,000 short, buyer gets to walk and keep their deposit. If there's a property-related condition, I had 2 times in the last month, I couldn't believe it. Nobody pushed the buyer's lender to get the condo questionnaire, and 3 days before closing, when I was hired by the buyer, I got to go in there and say, hey, is there a condo questionnaire yet? Yeah, we just got it yesterday, and the bank's looking at it now, and there were 25% investors and less than 10% reserves. And I turned back to the bank and said, are you sure you want to make a loan on a property-related condition like this? And they backed out, and we were able to get a full deposit back. The other thing, just while I'm on the phone on those issues, please remember, if you're representing a seller with a condominium, make sure you get every single document required by the condominium rider, send it to the buyer, and have them acknowledge receipt in writing of that. I was able to get 2 people out of contracts with full return of deposit because there wasn't one of those documents delivered. And when it was, we canceled statutorily within the 3-day time period and walked away.
Perfect. Awesome. Thank you. So regarding liability with showings and whatnot now, is there anything that you want to see written into the contract or that should be written into the contract to avoid the liability of the seller if a buyer shows the house or shows the property and has the virus or comes down with the virus or anything like that? Is there anything going on with that?
So it's really more important to have something in the listing agreement, not as much the contract. You're responsible to the seller for taking any reasonable actions to keep their property safe. And one of the things that you could say is, if you're very concerned, don't show the property for the next 30 days while we're in a lockdown period. And it's almost that takeaway sales strategy that seems to be working well, where you say, look, if you're concerned and you're conservative about this, I'm not allowed to go in there during a virtual showing. I may be able to open the door and close the door and make sure that, I don't leave the home unlocked when somebody else leaves, but I'm not going to be in a position to go walk around with them during the showing. And that's a risk for you for several different things. Theft, that's a risk for you for COVID. You don't know what they're touching. You can tell them to put gloves on. You can tell them to open door handles with a Clorox wipe, but you're not there to see whether they do or don't do it. And those are some real concerns. I've had some people who've worked language into their listing agreement saying that if you decide to show the house during this time period, you'll hold the listing agent harmless from any loss associated with personal property or any health-related losses due to infections from COVID.
Perfect. That makes sense. Dave Santangelo in Boynton, is there anything that you suggest to help bulletproof the transaction from the beginning as far as an addendum or verbiage in the contract, just to make sure, kind of similar to what we were just talking about.
Yeah, I think you can absolutely cross out paragraph 18G if that's the big issue. You could just either cross it out or put in paragraph 20 that that neither party will claim that COVID-19 is a force majeure, and that all parties shall be responsible to meet all contractual obligations and timelines, regardless of warnings that, and specifically say that buyer authorizes its realtor to conduct the pre-closing walkthrough. If you want to put that in there, that's probably a help.
All right, and last but not least, it looks like Nicole Warren. Is anything going on with acceleration clauses with mortgages that you've seen? Anything being modified? Anything going on with that?
So acceleration clauses for non-payment for.
I think it meant for non-payment. If you want to type it in the box, you can, Nicole.
Yeah, for non-payment. Like, with everything that's going on, people are maybe defaulting or trying to maximize their finances or something like that. So I just got a call from someone concerned about that, and I didn't know how to, guide this person.
So many of you know that my law firm helps distressed homeowners, and so we have a finger on that pulse quite closely now, and it really depends what kind of loan you're in and what your situation is. Right now, all of the banks are willing to defer payments for at least 90 days. The big difference is what the result will be at the end of 90 days. Many of these servicers who are servicing loans for Fannie Mae and Freddie Mac and FHA have different results. So Fannie Mae and Freddie Mac say, I don't care if the borrower didn't pay, you're the servicer, you keep paying me, even if they didn't pay you. That's the rule. That's why I'm giving you this servicing. And if you can't pay me, step out of the way and I'll assign this loan to somebody else who will. So those loans, the servicers are saying, hey, after 90 days, when you go to make that 4th month payment, you have to pay the last 3 as well. That's going to be impossible for people. They're going to default, period. So anybody who takes that deferral now, knowing that that's your only option at the end of the 3-month period, is heading down a bad path. There are some banks and FHA and other lenders who are saying, look, we'll give you 3 months up front and then we'll put it on the back of the loan. We'll just add 3 more payments to the back end of this loan. It's okay. And those are the ones that, why wouldn't you do it? And it's obviously everybody's going to have cash flow issues in the next 6 months. Take the time, take the money. And if they allow you to extend it for another 3 months, do that as well. Just put 6 months in the back of the loan. So you really need to counsel your clients to understand what type of loan they have and to be able to talk to their lender about the options specific to their loan. You can get the letters, and they're all standard letters. And most of the standard letters are saying, we'll gladly defer your payments for 90 days, and we'll have several options available for you at that time. That's not good enough. I've been telling my clients, don't go down that path, period. You want to get something in writing from the bank that says you'll have several options, including deferring it on the back end of the loan. And if they're not going to let you do that, then there aren't too many other options that are going to be good for you. One is refinance. So, you're finally 5 years into a 15-year mortgage and you're finally paying down a decent clip of principal every month. And now they're going to turn back to you and make you refinance for those 3 months of deferred payments. And you're going to go right back to paying $12 in principal every month. It's not fair and infuriating. So,
great. Awesome.
Okay.
Thank you very much for that, Paul. Thank you, Nicole, for the question. So, guys, we're going to wrap this up right here. If you guys do have any other questions, make sure to let us know. Reach out to Gab Bryce, Dave Ward, Melissa Kidwell, Tracy Cinder, or myself, and we will follow this on to Paul. Also, make sure every Thursday, you know that we're going to continue doing this. So Thursdays at 4, mark on your calendar, and we will continue with Better Call Paul.